Good afternoon. As you're aware, in the past few days, we have witnessed various levels of industrial action stemming from an employment dispute between the Bermuda Industrial Union and the Fairmont Hamilton Princess. At the earliest opportunity, the Ministry of Home Affairs was advised of the situation and sought to bring the parties together so that the issue could be resolved. I advised on Monday that under Section 5 of the Labor Relations Act 1975, in the interest of seeking a resolution, I referred the matter to a dispute panel on Saturday, 1st of February 2014, with each party being invited to appoint their assessors by 3rd of February. It was anticipated that since the matter was referred, both parties would withdraw any action until the arbitration process has concluded and ensured that business operated as normal as possible. However, earlier today, and for the second time this week, I have stepped in to address the ongoing industrial action, and this time it was regarding a dispute with the Bermuda Industrial Union and the Fairmont Southampton Hotel. In an effort to address this most recent impasse, this morning I also referred the matter to a dispute panel in the interest of seeking a resolution. Since referring the matters to arbitration, we witnessed a demonstration by union members, which included some public service workers, in support of the union's stance. My understanding this afternoon is that those public service workers have since returned to work for critical services. Yet, while we recognize the rights of workers to demonstrate in solidarity for their cause, we must be mindful that there are mechanisms in place which allow for the proper protocols to be followed so that it doesn't result in a disruption of services to the public. As it relates to the BIU Fairmont dispute, or disputes, at this time I can advise this afternoon the parties came together with a view to discussing the matter in accordance with the arbitration process. We will continue to do our due diligence to monitor the situation and follow the guidelines set out under the Labor Relations Act 1975 to ensure that we come to some form of resolution that benefits all concerned. Finally, I said earlier this week that the entire situation is very unfortunate for a number of reasons, and it is my sincere hope that the BIU and Fairmont can find some common ground on this. As a minister responsible for labor, I recognize and support the view that the rights of the worker must be upheld and protected. And I think we must be mindful of the current state of our economy and our hospitality industry. Our economy continues to be in recovery, and our tourism industry remains in a very precarious state. We must do all we can as a people and as a country to ensure that we protect and preserve what strides we have made in these very important areas. That said, I look forward to being provided a positive update from the Director of Workforce Development as it relates to the arbitration process. I'm happy to take a few questions.
Minister, as far as you know of the workers, have they agreed to return to work? Because we heard from the President, Mr. Ferber, today that they will not be returning to work until this is resolved.
Yeah, my understanding is that critical services in relation to school bus runs, and there will be a late-night ferry service as far as I'm aware to get people back home from work. My understanding is that after that there will be no further services. But we can hope that we will avoid further industrial dispute and action in that.
What if we can't resolve it by tomorrow, for example? What if it continues?
Well, the government's position in respect of the government workers is that we will follow the terms of the Labor Relations Act and the collective bargaining agreement to the T, which lays out how disputes such as these are to be resolved. So that's what we will do if it comes to that.
Have you heard anything about the 10 workers at Hamilton being reinstated today?
I have not.
Minister, clear this up for me. When the parties agree to arbitration, are they legally bound to always go back to work?
The collective bargaining agreement makes certain things clear from my perspective. The Labor Relations Act also makes certain things clear that industrial action should really come to a halt. There is some debate in respect of whether things all return to normal, and I think that's going to be part of the process going forward in terms of the discussions between the parties at Fairmont.
And the arbitration, when it resumed, or resumes, would all parties be required to be present?
The Act in respect of the reference makes it clear that the chairman of the panel can proceed whether or not there are assessors present or not. Again, different parties will take their different perspective in relation to their arguments before the panel. What I'm not going to do is presuppose their respective arguments, because that's a private arbitration matter between the Fairmont and the BIU.
And I don't want to sound like I'm putting you on the spot,
But you are.
is it evident, I'll ask, that the Fairmont, in their decision, went against the collective bargaining agreement?
Again, I'm not going to give my personal view on exactly how those things are worded. Each party has their ideas as to how things should be read and interpreted, and that's for them to make those decisions in their own way. It's not for me to presuppose that for them.
Any other questions? Don, did you have any questions for the minister? Yep.
So if the government workers do not return to work tomorrow, you gave us a very legalistic book answer. What does that mean in layman's terms as to what the government will do?
I wasn't intentionally being legalistic. Maybe that's just my nature. Again, the Labor Relations Act sets out very clearly as to how disputes of this are to be handled. And one should make reference to the Labor Relations Act. Under the Labor Relations Act, there are some areas called essential industries, for which hotels fall. And then you have some areas which are essential services, which include, say, stevedoring service, postal workers. In the event that parties do not agree to go to arbitration under the Labor Relations Act, then the minister has the right to make a reference under the Labor Disputes Act. So it's all quite convoluted. I'm trying to be as plain as I can. What I can say to you as clearly as I'm able is that the government would simply follow the acts that are laid out in respect of industrial disputes. And that means making the appropriate references as best we can to arbitration. If we can settle in between, then that's even better. But we have to follow the process.
Yesterday, when I was speaking with Mr. Ferbert, he said instead of getting emails, he would have appreciated a phone call from you to sort of bring the parties together. Just asking why that didn't happen.
I'm not privy to exactly what Mr. Ferbert said. What I can say is that I did reach out to the parties personally on Friday evening, as I said in my statement, both parties by telephone, and it was at that point very clear to me that there was a labor dispute and the parties were not going to come to a resolution, it says that under the Act, if the parties cannot come to a resolution, then at that stage the minister should be making a reference to arbitration, which is exactly what I've done. If the parties can't come to an agreement, I make a reference to arbitration. That's my role as a minister responsible for labor. It's not necessarily to get involved in negotiating. The director of labor or workforce development reaches out to the parties, which was also done. So I will say completely that I did make the relevant efforts under the Act on Friday evening.
Well, so yeah, I mean, you said you can't give your own personal view on it, and that's understood. But what is, from the union side, what procedure, or what aspect of the collective bargaining agreement are they saying has not been adhered to by Fairmont? My understanding from the union's perspective, and I say this, I'm not going to speak on behalf of the union, it's my understanding of what is happening, is that the collective bargaining agreement does lay out a process in respect of redundancies. Custom and practice has certainly been under the collective bargaining agreement, is their argument, that there should be an adequate and proper consultation prior to that. That is obviously their point to make, and that is a point that has been made by them and should be made, in my view, to the panel.